Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question from one of our loyal YouTube subscribers is the following. Hey Patrick, could you go over some of the common myths, fallacies, things that folks typically get confused about when it comes to estate planning? So pull up your chair, get your pen out. Number 4, I'll never end up in a nursing home, so I don't need to protect the family home from the metaphorical fourth-headed monster, maybe that $15,000 or $20,000 per month private paid nursing home. Sadly, I heard those words from my own dad years ago. And ironically, in the late fourth quarter of his life, after taking a bad fall at home one day, he ended up in a nursing home. It was very regretful. And then the family home was exposed to Medicaid, to the nursing home, and so forth. Hence the reason why, folks, if you desire to protect from the fourth-headed monster, Medicaid, the good news, the law says you can do that permissibly, but you have to do it 5 years in advance with creating a Medicaid Asset Protection Trust. We call it an irrevocable Medicaid Asset Protection Trust, completely permissible under case law and under Medicaid rules and regulations. But you have to do it 5 years in advance of ever becoming incapacitated. Make sure, folks, you work with an experienced elder law attorney that are going to not just protect the property from the fourth-headed monster, Medicaid, but also protect it from capital gains tax as well. I've seen some trusts recently, Medicaid-specific trust, irrevocable in nature. They were Medicaid-specific, but they did not have capital gains tax protections in there, meaning that the children later in life would get zonked with a large capital gains tax, in some cases over $100,000. Not needed so long as you have the proper language in there. Number 5, hey Patrick, can I just put my kid's name on the deed? No good, folks. I have another video on that on our YouTube channel. 5 reasons not to put your kids' names on your deed. And one of the biggest ones, folks, is capital gains tax. Because when you put your kid's name on the deed and they don't live there, when the house has to be sold, especially in your lifetime, they're going to get hit with capital gains tax, folks. Not a good thing, right? And then the other big concern is usually the elderly parent does that maybe when they're 80. Now, if they're 85, they can be completely incapacitated. Now they have to go into a nursing home. The nursing home could still put a lien on the life estate interest when folks have a life estate type of deed. So from my experience, putting your kids' names on the deed, big tax problem, also does not completely protect from Medicaid as well with that Medicaid live-in lien. And the other challenge is now the senior could be completely incapacitated and they do not have legal authority to sign the deed over if the house needs to be sold later in life. And that can happen on occasion as well. That's the 5 common myths about estate planning that you need to be clear about, because a will is not sufficient. Probate court is a big problem. Nursing home, if you desire to protect from the fourth-headed monster, you have to get that 5-year clock running 5 years in advance. And do not put your kid's name on the deed. Too much risk, too much problems in there. God bless you, folks. Thanks for being here. Pick up a copy of Book 1 on Amazon, Patrick Kelleher, How to Avoid the Four-Headed Monster, or Patrick Kelleher, The Top 20 Strategies That Will Help You Win the Battle, also on Amazon. God bless. Stay safe. Thank you.